Welcome back to the Environmental Law Monitor. I'm your host, Daniel Pope. This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Practice Group, and it's a place for thoughtful conversations. We have conversations ranging from the latest developments to perennial topics like litigation, enforcement, and compliance assurance. We're glad you're spending some time with us today. Welcome back to the Environmental Law Monitor podcast. I'm your host, Daniel Pope. This podcast is still brought to you, and will continue to be brought to you by Bracewell LLP. Now, I know before we even jump into our topics today that you may be wondering where we've been. We took something of an inadvertent hiatus. I attribute that to a lot of people, partially to me, partially to my 2-year-old having sleep regressions, partially to EPA enforcement and other news out of the agency trending way down. If you're like us here at Bracewell, you've probably been watching what EPA is doing. We saw some really big announcements from them in March and at the beginning of last year. And then we saw a downturn in new enforcement cases. We heard stories of attorneys and staffers leaving the agency. Maybe that's related to DOJ, maybe that's related to policies, but at the end of the day, some of those attorneys have gone to non-governmental organizations. We've not seen until just recently new major regulations. And so I think if you're like a podcast host and you're working for a company, you may be wondering, well, what should we be doing right now when we're not seeing a ton of activity from EPA on the regulatory front, on the enforcement front? And so to help us think through those issues together, I've invited, again, our go-to friend of the podcast and colleague, Tim Wilkins. Thanks for joining, Tim, as always.
Daniel, thanks for having me on.
You still have not worn out your welcome. It's great. So, Tim, as I think about, as I try to put myself in the shoes or the flame retardant coveralls of our clients, and I try to think about, okay, well, the administration is not necessarily dictating the terms of what my next 6 or 12 or 18 months looks like. And at the same time, they are the enforcement authority. At the same time, I want to make sure that I've got like a quality staff, that we're complying with the laws, that I'm not piling up violations that they're not identifying. Like, what do I do? What does proactive environmental compliance look like in this setting?
Yeah, before I dive into that, I do want to riff just a second on the concept you opened with. And it is very clear that new enforcement actions have dropped off a cliff. There are so many fewer enforcement actions in the federal environmental space, in the pipeline safety space. Stuff's been dropping off. We have seen anecdotally a number of the people leaving EPA, leaving DOJ, ENRD, going to NGOs. That was not a surprise. There have been expectations for many months that citizen suits were going to start cranking up, and that just doesn't seem to have actually happened. But
at least not yet.
Yeah, at least not yet. But we have seen in the sort of the legal press and the client alerts that other folks are sending around, in our own experience, notices of intent to file citizen suits have started showing up. And so I think that is an important contextual factor. I think it is also important to remember, with a 5-year federal statute of limitations on most environmental violations, what's happening now, even if it is not enforced by the current administration, is going to be available for enforcement in whoever the next administration is. And it is, I would say, a very risky strategy to say, don't worry, EPA isn't knocking at the door anymore, so we don't have to try as hard. I think that would be false comfort you're taking from what's currently happening in the enforcement space. So taking it to the question that you actually asked me, how do companies keep their guard up? How do companies stay ahead of the game? How do they not get lazy or not fall out of compliance in this regulatory environment? I think the answer to that is the fundamentals of environmental law remain. the fundamentals of rules, regulations, statutes, permits remain in place. One of my good friends and clients likened it to, hey, there's still speed limits, but we've maybe gone up from 75 to 85 on some of these roads. But there's still a speed limit and speeding's still illegal. So we need to be really careful in maintaining a strong corporate EHS compliance effort. Culture of compliance, staying fresh on the rules and regs that apply, making sure that your teams are strong and that they are putting in the effort. But also, I think there's a reality that people in the last administration were scrambling just to keep up with all of the new rules that were coming online in an era where there aren't new requirements being added and some of the recent requirements are actually being rolled back. A company has a real opportunity to use the energy they were expending in that scramble on really buttoning things up tight. And that means, again, starting with a team that's really talented, invest in training and recruiting well. I would say make sure that your EHS staff feels empowered internally to speak up when they see things that need help. I think affirming broadly to your ops teams and others that EHS remains a priority. Whatever you're reading in the newspaper, this still matters to us and we're still committed to the compliance effort. I think those are a really important place to start. Anybody who's listened to me and Daniel talk before know that I'm a hammer and all I see is nails. So audits are always a real part of that solution, making sure you're independently validating your compliance effort. And then there's just a concept that I think a lot of people don't necessarily get. And that is when you are undertaking this effort to comply with the environmental laws, compliance is step one. Being able to prove that you've complied is step two. Step three is to make that proof just easy. So when an inspector shows up, you have all the documents right there on hand that show compliance. You know exactly where they are. If something went sideways and you managed it appropriately or you had interactions with the agency, that you've got that demonstration with a nice bow around it. So when the inspector says, what happened with this? They receive a piece of paper or a stack of paper and say, well, okay, that's not a problem. You dealt with that perfectly. Being able to prove that stuff is so hard to do.
And I think that part of it is the show me, don't tell me aspect of environmental compliance. When somebody's at your facility and they're asking to see records and you can go and you can say, oh yeah, I know where those are. It'll be out in 2 seconds. Let me go pull them up for you. You're showing them that, hey, we take environmental compliance seriously. And I think that that's so obviously so much better than just saying, oh, we take environmental compliance seriously and then not having anything to show for it. Those kinds of actions, they help win the story, right? And I think so this is a great point.
Think about that just for 1 second. Daniel and I do a lot of corporate transaction stuff together. And when you're doing environmental diligence on a seller's assets, on the company itself, and you walk into a data room that everything is tight, everything's dialed in, it's all there. Everything you would expect to see is there, stuff that you might not even expect to see. It's there, it's explained, it's in order. You just get this sense of comfort that this is a well-managed EHS enterprise. Exactly. And when you, on the other hand, see a data room that's half populated, it's kind of a wreck. When you ask the follow-up questions, hey, can you give me these documents? And it takes 3 weeks to turn that. That does not give you confidence. It does not inspire confidence that the company's got its act together. And having that buttoned up, really provable approach to this, it's invaluable in the enforcement context and in the transactional context.
I think another thing, we're sort of talking about here when you have an empowered EHS team, what you're really aiming to do, at least as far as potential enforcement goes, is you want to prevent the violation from occurring. you're engaging those core functions of your EHS team to prevent violations because they're training staff or they're advising on permitting or they're advising on this, that, or the other aspect of what's going on at the facility that day. You're preventing compliance issues when you're training your EHS staff. But let's talk a little bit about what happens when our well-trained EHS team, through no fault of their own, comes across a compliance concern. Like what tools are there to sort of, if we can't prevent an environmental compliance concern, well, what do we do to mitigate it so that it doesn't become a bigger problem going forward?
Yeah. So, I would say that there are two answers depending on what and how much you've discovered. If what you find out is, hey, we don't know what happened here, but it doesn't look great, you have an opportunity to press the audit button. You have the opportunity to say, you know what, I'm going to do an investigation. I'm going to figure out if we've got a violation. I do not know today if we've got a violation. I've got a program area that I don't have as much confidence in as I should have. And so I'm going to really go do a deep dive under, the Texas Environmental Health and Safety Audit Privilege Act or EPA's audit policy, depending on what the issues are, right? And reference back to our webinar from earlier in the month. Sometimes there are federal lead issues where EPA is the only answer. Sometimes the answer is it's going to be state lead. And so you want to look at the state you're in and whether there is a state audit policy that might provide you some protection, whether it's privilege, whether it's immunity, whether it's leniency for the things that you might find.
To riff a little bit on, what it is you found and whether you found it. One of the things we talked about in that webinar, and if you're curious about that webinar, email me. We'll make sure you get a link if you missed it. But audit programs typically require you to announce or intentionally take steps to audit yourself. And then you discover the violation. Well, what happens if you discovered the violation, right? One of the things that, say you have a pretty good idea of what happened, that it's wrong. You can still leverage those federal and state audit programs to find other things connected to that, that issue that identified the concern to you. You can hop around and look for adjacent problems. So just because you've discovered something, doesn't mean that you've missed your opportunity to leverage those programs. And so for that reason, I think they're incredibly powerful. Should really just in very, very few circumstances be considered off the table.
Right. Quick example. I am familiar with circumstances where somebody has identified an air emissions exceedance. And it's like, okay, that's, it's a Title V facility. I'm going to have to report that. This is discovered outside of an audit context. And so I don't really have an opportunity to use the audit disclosure tools that are available to me when I haven't discovered something. But what happens if those emissions also impact other aspects of your compliance program? That exceedance may reflect a violation of another term of your air permit that talks about, maintaining controls. Maybe it involves TRI regulated emissions, and you've been underestimating what you've been reporting on your TRI forms. So there are opportunities to expand, even if you've discovered outside of an audit. And again, I think to the prior point, if you've identified something wonky, whether it's just impressions or whether it's I found a violation, that could inspire you to say, man, I need to audit that program area, because if we mess that one thing up, there could be other things within the same program area. And that's, I think, really a healthy instinct on the corporate compliance hygiene to take that dive. There's also, the fact pattern where you've found a violation, it's not eligible for audit disclosure. What do I do now? And that is just so context specific. Do I go to the agency and self-disclose even though I don't have an audit angle? Maybe, maybe not. Do I just dive in and fix it, or do I deal with this as part of a larger strategy? Do I install some temporary fix with the idea that a longer term solution could involve an operational change that just is going to take some more time? There's so many factors and so many ways to approach that. There's no one piece of advice that works there. There's no one size fits all for for that sort of scenario, I would say.
Going back to, I think, one of the points we began our conversation with, that you've got to do something to address the non-compliance you find, because we're now in that period where a violation today can be actionable by a future EPA under a Democrat administration, right? And if those enforcement initiation policies shift, and we suspect that they will, whenever there is a color change in the White House, we see that approach change, especially for things where you are recording your compliance status and it leaves a mark in your records, right? That's actionable now. So that can also either be a continuing violation problem to explore that more, or you can cut it off and say, hey, this happened in February 2026. We resolved it by March 2026. There's no violations from that date onward, and that's your statute of limitations date, right? So,
well, to even double down on the importance of that, when you have discovered a violation and you allow it to continue, it's no longer just a violation, it's a knowing violation.
Right.
And, again, I don't anticipate this administration is going to commence a lot of federal criminal enforcement in this coming 3 years, absent really egregious circumstances or really egregious headlines. But man, that if you leave something out there uncorrected after discovering it, and we get around to the next administration and the next administration has a different attitude on enforcement, that's a serious, serious exposure. And I would say, again, it's not just red versus blue. Even for a red administration, this administration has taken a notably different tack on enforcement than prior Republican administrations. And so I think I would, this is a feature of the current administration. Whatever happens 3 years out is likely to be different than what we're experiencing right now.
I would hazard a guess that if, we talked earlier about making sure that your EHS personnel know their areas that they've been tasked with thoroughly, right? And that this presents an opportunity, because you're not responding to new regulations, to get the basics down pat, right? To understand the rules as they're reasonably interpreted today and how they apply to your particular facility or your particular operation. You know what I think would be like kind of a risky position to be in, even with this administration, is to not be performing well on those sort of core functions. We know from this administration that they're not going to squint at the statute or the regulation and try to come up with a novel theory of enforcement. But if you're outside of sort of the best understanding of what a statute or a regulation requires, like that's a not great spot to be in.
One of the great things about working at a firm like Bracewell in a practice like ours is that we're working with companies that do hire the best and the brightest. They're hiring hyper competent EHS professionals, over and over again. It is rare that we run into a situation where one of our clients does not have the great EHS staff in place. But sometimes when folks get in serious trouble and didn't really have EHS staff in place, we've ended up helping people dig out of that in either audit or enforcement contexts. And I think there's a lesson learned component of that. But yeah, if you're involved in heavily regulated activities and don't have a best and brightest EHS staff at your disposal, that is something to really, really make sure you're picking up.
Well, so we've kind of suggested that maybe federal scrutiny of our clients or sophisticated industrial or petrochemical companies, fill in the blank, maybe EPA isn't scrutinizing them as thoroughly as it has in the past. But that doesn't mean that no scrutiny is occurring, right? We mentioned earlier that non-governmental organizations are they're lawyering up. They're becoming more active. They're watching. They're sending in FOIA requests or, other sorts of FOIA style requests in the States. I think one of the things that you've got to do, even if you're not worried about the craziest regulations coming out of EPA and being published in the Federal Register, you do want to know what the NGOs are concerned about, right?
You absolutely do. And before we even dive in on NGOs, I mean, the states are very, very active on enforcement, and don't sleep on the red states. I mean, there are real enforcement programs in each of these states. I'm thinking of Texas, where we practice more often than any place else. But like TCEQ has a very active enforcement program. I'm still doing a great deal of enforcement defense work on that. And like I remember seeing just the other day that, Ken Paxton, I don't know what you have to do from an environmental perspective to get on Ken Paxton's bad side, but the new enforcement case against Darling Ingredients and the, nuisance odor stuff, that's a real enforcement action. And you cannot expect that nobody's going to do anything. But yeah, you're exactly right that the NGOs are paying attention to this stuff. We haven't seen it all manifest yet, but knowing that they're staffing up, knowing that they're interested in this stuff, and knowing what their priorities are over and over again, they're publishing policy pieces and white papers on, the refining industry, this, the chemical industry, that, whether it's fence line monitoring or whether it's, some specific chemical issue. If they're publishing white papers on how bad X is, and you're doing X, you should be expecting that at some point, Sierra Club or whoever is going to knock on the door. So it's really, I think, important to watch what the NGOs are up to, watch carefully at what they purport to care the most about, and to get on that, get that fixed as soon as you can. It not only diminishes the reasons that they would pursue a citizen suit against you if you've got the problem fixed, not only cuts off the period of penalty that might run, but in the citizen suit context, at least under some of the statutes, if you have stopped the violation, it's now moot. Their citizen case is now moot, and they can't proceed. It's got to be an ongoing violation in some of these contexts. And so, like, there's real incentive to me as a corporate to be thinking about, what are they going to be coming after people on? Do I have exposure on that? And what can I do to kill off that exposure as quickly and as thoroughly as possible? And again, not just fix it, but fix it in a way that's easily provable.
And fixing whatever your compliance concern is. It does work in the citizen suit context, and it does work in the agency enforcement context, whether it's coming from a state, whether that's coming from EPA. I think one of the questions that is sort of implicit in those agency enforcement actions is, okay, well, am I looking at a good company that just makes mistakes because, hey, this is a complicated area of practice. These are complicated regulations. These are complicated facilities. It would be easy to make a mistake. Or am I looking at maybe a bad company, maybe a company that doesn't take environmental compliance seriously? Have I talked with this company about this issue in the past 2 years, in the past 3 years? I think one of the key drivers of both monetary penalties and injunctive relief obligations, which those can be so costly and they can really dwarf a penalty. One of the questions I think is often, am I looking at a repeat situation? After I issued an administrative enforcement order to this company, did they continue to employ an undertrained or underqualified person in that role? Did they supervise them, et cetera, et cetera, et cetera? Have they ignored warning signs? Again, fixing this, empowering those EHS teams is such a crucial tool to prevent. And then when you have to respond, you can actually describe what you've done positively to try to achieve environmental compliance goals.
Yeah, it's exactly right that when you've got repeat violations, the penalty policies, federal and state, very commonly provide for an immediate escalator if you've got a repeat violation. So that's an important piece there. But I think, just the overall landscape of how the agency is going to view a potential enforcement opportunity, if it looks like you had a violation despite demonstrated best efforts, that's going to get a different response than somebody who has a violation because they're sloppy, lazy, not doing the job, not trying very hard. And I'm not sure the agencies can always distinguish But you, as a company and an EHS leader, have the ability to make sure that the agency comes away with the former impression instead of the latter. You can make sure it's not gray, that it's not a question, that it is, despite best efforts, not because of sloppiness. And that goes to, again, the personnel, it goes to the systems, it goes to the culture, and it goes to being able to prove what you did in a way that's just readily accessible, readily demonstrable. You can impress the enforcer, you can impress the inspector by doing this really carefully and doing it really correctly.
Thanks, Tim. Let's wrap up. I mean, I think the big takeaways from our conversation are, do what you can to prevent the occurrence of environmental violations, right? Invest in those strategies because, that means there are a lot of benefits from that. Sure, it is an investment, but you are potentially avoiding penalty amounts, injunctive relief requirements, agency scrutiny, and even reputational risks with that agency and fence line communities. I think you want to mitigate the compliance issues you do find where possible. And that's all sort of about wanting to be active in environmental compliance. And then when you achieve that level of compliance, you're going to be able more successfully to respond to enforcement. You're going to be able to respond to citizen suit litigation and other risks that you might be dealing with. Well, thank you guys for checking in with us again. We are getting back into the studio more frequently. We've got a couple of interesting conversations we'll be recording here in the coming weeks. So don't delete us from your subscription list if you haven't already, and resubscribe if you have. Thank you guys again for spending time with us. We will talk to you soon. That's it for us today at the Environmental Law Monitor. Big thanks to our guests and the rest of our production team who helped to make this episode possible. And of course, thank you, our listeners, and we'll talk to you soon.